Calling the committee to order. A quorum is present. The hearing of the subcommittee will come to order. Pursuant to Committee Rule 12A, any member may submit an opening statement in writing which will be made part of the permanent record. Before we begin, I would like everyone to take a moment to ensure that your cell phones and Blackberries are on silent. Actually. I would now like to ask unanimous consent to allow the distinguished gentleman from Virginia, Mr. Scott, and the distinguished gentleman from New York, Mr. Bishop, to be allowed to join us on the dais today and participate in the hearing. Without objection, so ordered. I now recognize myself, followed by the Congressman Davis from Tennessee, for an opening statement. I want to thank all of you for being here today for our hearing on the Juvenile Justice and Delinquency Prevention Act. Today, we will continue our research and education as we work towards the reauthorization of JJ. As it is with elementary and secondary education, the federal government's role in juvenile justice is to create a guiding framework or incentives for the states. The states then work within that framework to implement their own juvenile justice systems through laws and regulations. For us, there are issues to explore as we work to craft a framework for the states that will work to benefit our young people and ideally prevent them from being incarcerated. Today we will seek an understanding of the nexus of the child welfare system and the juvenile justice system. Previous hearings have made it clear to us that these two systems do not intersect, and yet they often fall short of helping each other or even communicating with each other. The challenge is to foster a complete system of care for our young people so that we can divert them away from the JJ system or get them education and proper care while in the JJ system. Along those same lines, we will explore the connection of mental health to the JJ system, again looking at both the care of youth in the JJ system, but more importantly, the prevention of youth suffering from mental health issues from entering the system. Critical to the experience of a young person in the JJ system is the judge who presides over the case of the young person. The decisions made by the judge determine the future of the youth and an immense responsibility. We need to understand how judges function within the framework of JJDPA and what alternates judges have to incarcerate based on their state laws and regulations. Each of us on the subcommittee is committed to helping the young people of our nation, and they need our help. We are not meeting the needs of our nation's young people very well. For example, many are afraid to go to school for fear of being bullied, and children get lost in the multiple systems meant to protection or help them. Today, we will explore how to improve the JJ system, but I think we all agree prevention and addressing needs on the front end would do much, if not more, to improve the juvenile justice system. Again, I want to thank you for being here today, and I look forward to your testimonies. I now yield to Congressman Davis from Tennessee for his opening statement. Thank you.
Good morning. Thank you for joining us for another hearing on the Juvenile Justice Prevention and Delinquency Act. Chairwoman McCarthy, I'm pleased that we're continuing our focus on improving the juvenile justice system. We know that investing in prevention methods now will save substantial resources in the future. I am pleased to see a diverse panel of witnesses that can provide us firsthand knowledge of the juvenile justice system, describe how the federal law is administered at the state level, and provide insight as to which programs are working efficiently and which ones need improvement. One of the most important things that we can do as legislators is to craft legislation that prevents juvenile delinquency and encourages healthy child development. Although I recognize the aggressive fall agenda that the majority is planning, I am hopeful that we will produce a bipartisan reauthorization bill before JJDPA's expiration this year. Finally, I would like to thank all the panelists for being with us today. With that, I yield back to Chairwoman McCarthy. Thank you.
Thank you, Mr. Davis. Without objection, all members will have 14 days to submit additional materials or questions for the hearing record. I would now yield to my colleague, Mr. Bishop, to introduce our first witness, the Honorable Deborah Cooperstein. Next, go ahead.
Well, first let me thank Chairwoman McCarthy for giving me this honor and for yielding to me, and say that it is a true honor to have the opportunity to introduce my friend and colleague Deborah Cooperstein to this committee. Judge Cooperstein is the first female judge in the history of Southampton Town. She was first appointed to that position in 1993 and has subsequently been reelected to that position three different times. As a judge, Judge Cooperstein has been an innovator. She's made several changes to the court system, including instituting a law student intern program, installing a Spanish interpreter in the courtroom, and she authored a successful grant proposal to hire advocates for victims of domestic violence. She also has been appointed by the Deputy Administrative Judge to preside over one of 2 drug courts handling cases for the 5 East End towns in something called the East End Regional Intervention Court, and I have had the honor of attending one of the graduation ceremonies of that drug court, and I can attest that it has worked really in a remarkable fashion in terms of dealing with that segment of our population, and the leadership that Judge Cooperstein has provided has truly been inspiring. So it is a pleasure to welcome you to Capitol Hill. It's a pleasure to see you again. I look forward to your testimony. Thank you, Madam Chair. I yield back.
Thank you, Mr. Bishop. Next, I would like to yield my colleague from Pennsylvania, Mr. Altmeyer, to introduce our next witness, the Honorable Kimberly Clark.
Thank you, Madam Chair, and I'm honored to have the opportunity to introduce the Honorable Judge Kimberly Berkeley Clark of Pittsburgh, Pennsylvania. Judge Clark has served in the Allegheny County Court of Common Pleas since her appointment in March of 1999. Currently, she is the Administrative Judge of the Family Division in Allegheny County. Prior to this position, Judge Clark served as the Supervising Judge of the Family Division's Juvenile Court. In her capacity as a Juvenile and Family Court Judge, Judge Clark has been appointed to a variety of committees and boards relevant to today's discussion, including Pennsylvania's Domestic Relations Rules Committee, the Pennsylvania Juvenile Court Judges Commission, and the Governor's Commission on Children and Families. In addition, Judge Clark recently ended her term as president of the Allegheny County Bar Association, where she was the first African-American woman to serve as president. Prior to serving on the Allegheny County Court of Common Pleas, Judge Clark was an assistant and deputy district attorney in Allegheny County for almost 16 years. While in the district attorney's office, Judge Clark headed the Crimes Persons Unit, which handled all of the sexual assault and child abuse cases in Allegheny County. As an assistant and deputy district attorney, Judge Clark tried over 150 jury trials, including the first gang-related and drive-by shooting homicide cases in Allegheny County. Judge Clark is a frequent lecturer, speaker, and panelist on the subjects of child abuse, sexual assault prosecution, and juvenile law. She has clearly the wealth of experience to address this committee today, and I am pleased that she has taken time from her job to join us today. Thank you, Madam Chair, for the opportunity to introduce Judge Clark.
And thank you, Mr. Altmeyer. Our next witness, Ms. Janice Garcia, comes to us from the Office of the Governor of Arizona. Mr. Gahalva wishes he could be here. We were actually upstairs working on Leave No Child Behind, but he is also a chairperson of a subcommittee, and that's where he is. And let me say at this particular point, too, many of the members care passionately about this issue. And we have members sitting here today that are on the Full Education Committee, and they asked to sit here. So even though it looks sparse up here, believe me, all your words and your testimony have been read, because it's something that we do care about. Anyway, we wish he could be here to introduce you, but he is chairing another hearing at this time. Ms. Garcia is the Deputy Director of the Governor's Division of Children, which works to promote a coordinated and integrated system of care for children, young people, and families. Furthermore, the division also oversees the Juvenile Justice Program. We look forward to learning of Arizona's work in coordinating its child welfare system and the juvenile justice system. Our next witness is Dr. Weissman, who will share with us her extensive experience in enterprise working on mental health issues surrounding young people in the juvenile justice system. In her current position, she oversees all medical and behavioral health services for youth detained or committed in Washington, D.C. She has served in many director positions as a mental health expert in court cases and authored papers on the mental health needs of incarcerated individuals and how conditions of confinement as they impact the mentally ill. We expect to learn from you about what we can do to improve the juvenile justice system in regard to mental health. Next, we will hear from Dr. Stephen Ois. He is the Assistant Director of the Washington State Institute for Public Policy in Olympia, Washington. His expertise is in cost-benefit analysis to be used in both the public and private sectors. Today, he will share his work on examining aspects of the juvenile justice system and the challenges and the results of states which have been implemented, some of his recommendations. We will look forward to learning how he can help states implement evidence-based research into policy from you. Our final witness, Anne Marie Ambrose, is here today to share Pennsylvania's work on its JJ system. Ms. Ambrose, a 13-year advocate for young people in the JJ system, currently is responsible for the operation of 4 regional offices, which serve various public and private child welfare and juvenile justice needs. She will share with us the forward steps that Pennsylvania has taken to address delinquency and other aspects of the JJ system. For those of you who have not testified before this subcommittee, let me explain our lighting system. Split between you, you'll see a lighting system. It's going to be green, yellow, and red. It's a shame that we can only really hear your testimony for 5 minutes because I know you have a lot more. And the same will go for the members. We have 5 minutes to ask questions. And after that, I give a little bit of leeway. And I'll do a light tap with my nails. If I have to, I'll go to the hammer, which, and I don't like doing that. So I don't have to say any more about that. We will now hear from our first witness, Judge Cooperstein. Oh, and the mics. Just push the little button.
Congressman. Okay. Good morning. Thank you very much for inviting me, Congresswoman McCarthy. It's an honor for me. I am a town justice. For those of you who don't know what that means, I am a part-time town justice. I practice law when I am not sitting on the bench, and I have been doing this for 14 years. I am considered a judge interested in problem-solving courts. I know my time is precious, but Congressman Davis, I cannot resist telling you that I'm a Lady Vols season ticket holder and go down to Knoxville at least twice a year. In any event, I've been asked to talk about the East End Regional Intervention Court and our youth court and why they dovetail. I am an adult court, criminal court judge. However, in New York State defines an adult as someone 16 years of age. And frankly, I believe that classification causes difficulties for that teenage offender. I have on my docket at least 3 dozen 16, 17, and 18-year-olds charged with serious crimes, most of them involving drugs. I've been very fortunate to have had the opportunity to start this East End Regional Drug Court because so many of those teenagers really need the supervision that weekly appearances before a judge provide with drug testing every single day if necessary. Now, why that's important is because they are children, even though they're not juveniles within our state system. And why do I say that dovetails with our youth court? Because this year, we redefined and reorganized our youth court. We have a youth bureau in our town of Southampton now, which administers the court, but for the first time, the judges are involved. So we follow what is known as a restorative justice model, a problem-solving court. So there are real cases being heard by these teenage jurors, being prosecuted by these teenage prosecutors and defended by teenage defense attorneys, and they are mostly going to be drug cases. In the past, we really had just quality of life cases in this court, but it turned into something, although valuable as an exercise, it really was a moot court competition. Now it's a real trial situation, and they're dealing with juveniles who have probation officers. These cases are referred from probation. And I think it's very, very important to see how these problem-solving courts can help. We have a DARE program that ends in the 6th grade, and then in those very critical junior high school years, these children are left adrift. with a combination of our youth court that is operating now and doing very, very well, and our East End Regional Drug Court, which has graduated a number of teenagers with heavy, heavy drug charges against them, I see a real progress in our town. Congressman McCarthy, Woman McCarthy knows this, that we have not had one person who graduated from our drug court rearrested in over 3.5 years. And although our pool is very small, 28 graduates, I think it shows that if you have a judge who is actively supervising any court, be it a juvenile court or an adult court, and you have accountability, and you can reach defendants who are charged with nonviolent crimes, you're going to have results. The combination of intensive rehabilitation, supervision, accountability, and a judge, I believe, is a combination that brings good results. And it, for me, supervising the youth court this year and being one of the East End Regional Intervention Court judges is truly the best part of my job. And my law firm, where I practice 2 out of 3 weeks, has been very supportive of me, and I'm allowed to go every Tuesday afternoon and preside. Although this Tuesday, I explained that I believed it was more important for me to come down here and speak to you. So we will be testing our defendants today, and I'll get the report on my BlackBerry. But I thought today, if I could get your ear and tell you that with very few resources, and I'm talking about a budget of our youth court of $3,000 a year and a budget of our East End Regional Drug Court of $45,000 a year, you get results. Results that last. And I have many people in my drug court who I've put in jail before. 17-year-olds tell me they started using when they were 11 or 12. They are the best source of information for me. And I want to thank you very much for your time and attention.
Thank you, Judge Cooperstein. Now we'll hear from Judge Clark.
Thank you. Good morning. Madam Chair and members of the subcommittee, I'd like to thank you for this opportunity to testify before you today. And I'm pleased to have the opportunity to comment on the proposed reauthorization of the JJDP Act and continuation of JJDP. And I'm here on behalf of the National Council of Juvenile and Family Court Judges, and the National Council supports the reauthorization of JJDPA and the continuation of OJJDP. I was specifically asked to talk to you today about what I can and cannot do as a judge in Pennsylvania to help children and families, to describe what continuing education is like for judges, to describe what alternatives there are to incarceration of juvenile offenders in Pennsylvania and how often I feel free to refer youth to these programs, what preventative measures I recommend to help prevent youth from entering my courtroom, and the challenges that judges like me continue to face every day. This is difficult to do in 5 minutes. I would like to begin with this thought to help put things in perspective, and this goes to how most of society, I think, feels about juvenile and family court. There have been times when I've encountered a person, and upon discovering that I'm a juvenile court judge, they make a comment to me like, oh, it's so awful that you have to work with all those bad kids and all of those bad parents. And statements such as this couldn't be more wrong. And I acknowledge that there are some bad kids probably and some bad parents, but they represent a very small fraction of the cases that judges see. What I mostly encounter are kids and parents in bad situations, and I mention this because when we talk about delinquency, we can't talk about delinquency without talking about dependency and custody and protection from abuse and all of those things. And I always say that we define and label our kids by how they first enter our courthouse, whether they come in through the child welfare system or the juvenile justice system. I see people that are affected by poverty, drug and alcohol addiction, mental health stability, homelessness, mental retardation, youth, kids having kids, or combinations of some or all of the aforementioned. What I see is parents who do love their children but don't have the tools to properly raise and nurture them in this society today. And I see kids who are really bright and would have so much potential, but for their dire circumstances, which provide them little chance for hope or success. and as a result, they make poor choices. These children and their parents struggle every day, and some of them are just really existing instead of living life to its fullest and looking for goals. And I'm saddened by the fact that the public does not see what I see, and that sometimes society tends to look the other way. As a family court judge, I hear dependency cases, child welfare cases, delinquency cases, which are juveniles charged with committing crimes. I hear termination of parental rights and adoption cases, custody cases, protection from abuse, mental health commitments, and drug and alcohol commitments involving juveniles. As a juvenile and family court judge, I make decisions that forever affect the lives of children and families in my county. I remove children from their homes and communities and from the care of their parents and from everything that they know and maybe are comfortable or familiar with because they are in need of treatment in an out-of-home setting. I terminate parental rights and finalize adoptions. Though on occasion I make decisions that results in a child being tried as an adult rather than a juvenile. But with the help of many who work in the system, I am sometimes able to have parents reunify with their children, juveniles successfully complete their conditions of supervision, and their cases are closed, and in some cases, children have permanent and lasting relationships with adults. In Pennsylvania, we're fortunate to have many other options than secure incarceration for juvenile offenders, and we utilize residential programs for many of these offenders. And obviously, the key is prevention and providing services and education for judges, and OJJDP helps with this. And to sum up, I would say judges in my position, we need to have adequate training. We're asked to be part social worker, part physician. We're supposed to understand developmental goals, behavioral issues, drug and alcohol addiction, psychological issues, the dynamics of sexual and physical abuse. And with this, we need training, and we need collaboration and cooperation with others. And OJJDP helps with this in terms of the training. And I thank you for this opportunity to be heard today.
Thank you, Judge Clark. Ms. Garcia?
Okay. Good morning. I'm honored to have been asked by Chairwoman McCarthy to speak on behalf of the Juvenile Justice Delinquency Prevention Act and the link between child welfare and juvenile justice. As Chairwoman McCarthy mentioned, one of the duties of the Division for Children, which I oversee, is to staff the Arizona Juvenile Justice Commission, which is Arizona's state advisory group on juvenile justice as required by JJDPA. I was also a member of the state advisory group for 6 years prior to coming into my current position. So prior to joining the governor's office, I spent over 20 years working with troubled youth and families in the community. My experience allowed me to see firsthand the devastation caused by young people by abuse, abandonment, and family disruption to young people, and the barriers to improvement caused by a siloed system of services, a challenge throughout the United States. One of the most consistent programs for youth in my years in the community was the Juvenile Justice Delinquency Prevention Program. And I was happy to see that in the most recent reauthorization of the JJDP Act in 2002, this body recognized the link between child maltreatment and juvenile delinquency and articulated requirements that promote the interaction and coordination of child-serving systems. Unfortunately, the additional priorities, coupled with a 55% decrease in federal funding over the last 5 years, has hindered efforts by the states to make reforms in this area. So what is the link between child welfare and juvenile justice? In 2005, there were nearly 900,000 substantiated cases of abuse and neglect in the United States. The Child Welfare League of America's review of the research found that victims of child maltreatment are 59% more likely to commit delinquent acts and 1/3 more likely to commit violent acts as adults. Maltreated children are also more likely to experience a range of mental health, substance abuse, occupational, and educational problems during adolescence and adulthood. A National Council on Juvenile Justice study on Arizona youth found that an incredible 73% of youth ages 14 to 17 with an active dependency had at least one delinquency referral, 49% were on probation, and 51% had been detained. Clearly, we must do better to identify and divert these children and youth at the earliest possible point. Arizona has set about making changes in our system to address these issues. In January 2007, the directors of the Departments of Health Services, Economic Security, and Juvenile Corrections and the chair of the Committee on Juvenile Courts signed the letter of agreement supporting duly adjudicated youth and the accompanying framework for interagency practice that was developed by an interagency task force. In May 2006, the Arizona State Advisory Group and the Governor's Division for Children jointly held a Child Welfare Juvenile Justice Summit for 15 multidisciplinary county teams and a state team, out of which the Interagency Coordination and Integration Initiative was established. A set of outcomes and strategies have been developed, and multiple committees are moving forward on priorities, including publication of an information sharing guide, organization of data across systems for better service delivery, and development of prevention initiatives to divert youth from going deeper into the system. Our county teams have also moved forward with on-the-ground reforms, including that Maricopa County has co-located staff from probation, child welfare, and mental health at their juvenile detention centers to develop joint plans of service, and Pima County now holds child and family team meetings in the detention centers to move low and medium risk youth out of detention with appropriate support. The Arizona State Advisory Group has continued to provide leadership and financial support for these efforts. I would respectfully recommend that Congress expedite reauthorization of the JJDP Act, incorporating language being proposed by the Child Welfare League of America and their colleagues to further strengthen and define the expectation for states to address the link between child welfare and juvenile justice, that Congress restore and increase funding of the JJDPA so that states have the resources necessary for studying, planning, implementing, and evaluating coordinated and integrated approaches to service. And finally, that OJJDP work together with national leaders, including CWLA and NCJJ, to capture and disseminate effective strategies from the field for collaboration and integration. Thank you for your concern about this issue, and thank you for giving me the opportunity to speak this morning.
Thank you, Ms. Garcia. Ms. Weissman?
Can do this. Very good. Thank you for the opportunity to speak to the subcommittee, to the members of the Subcommittee on Healthy Families and Communities. I'm a doctor of clinical psychology and the director of health services at the District of Columbia Department of Youth Rehabilitation Services. Prior to my current position, I was director of behavioral health services at the Maryland Department of Juvenile Services. Public officials and advocates in both mental health and juvenile justice welcome your concern about the very serious issue of the prevalence of mental health disorders among youth who come into contact with the juvenile justice system. While juvenile arrest rates have generally declined since 1997, there are still over 2 million youth who are arrested and who come into contact with the nation's state and local juvenile justice systems each year. The now widely accepted prevalence data indicate that as many as 70% of youth who come into contact with the system have one or more diagnosable mental health disorders, and that as many as 25% suffer serious disorders causing impaired functioning in one or more life domains. By comparison, it's estimated that 10% of children and adolescents in the general population suffer from mental illness severe enough to cause some level of impairment. But these data alone fall short in really understanding the complexity of the issues our youth and our systems face in addressing these problems. There are other statistics we need to consider to really put this into context. For example, children of color are disproportionately represented in juvenile justice systems across the country. The data clearly show that youth of color are more likely to be arrested, locked up before trial, sent to state facilities after adjudication, and spend more time incarcerated than white youth, even when they're charged with the same categories of offense. But there's one more context-setting parameter. There is growing evidence documenting the nearly pervasive experience of trauma among incarcerated youth prior to incarceration. Some studies report prevalence rates as high as 93% for boys and 84% for girls. Trauma refers to the experience or exposure to violence, physical, sexual, or emotional abuse, or neglect. Trauma for these youth comes in the form of family violence and close contact with violence among friends and in their communities, in addition to being victims. The trauma our youth have experienced is pervasive, and it is multi-generational. If we don't treat the whole family system, we will be less successful in responding to the needs of our youth. Juvenile justice systems have struggled to develop the range of behavioral health services that satisfactorily address the needs of children and families. For example, the partnership between the MacArthur Foundation and the National Center on Mental Health and Juvenile Justice through the Foundation's Models for Change initiative has led to some significant improvements in the collaboration strategies between state-level mental health and juvenile justice agencies. In addition, SAMHSA's Center for Mental Health Services system of care work in numerous states has provided both the philosophy and the strategies for interagency collaboration among child-serving agencies, including mental health, child welfare, education, and juvenile justice. Children and adolescents cross multiple agencies and programs, and services must come from the combined efforts and collaboration among them all. There are several core values and strategies in approaching these problems, many of which are already embodied in the Juvenile Justice and Delinquency Prevention Act. We must deinstitutionalize status offenders. For status offenses are those that only a minor can be charged with, such as truancy, running away, and curfew violations. These are the very behaviors we would expect from a youth being sexually abused or otherwise traumatized. Incarceration is not good for anybody, and for traumatized youth, it recapitulates their original trauma experiences. A critically important development in recent years is the systematic identification of youth with mental health or substance abuse disorders as early on as possible. We must screen youth with validated instruments upon their first contact with juvenile justice agencies, and this screening must lead to culturally sensitive, evidence-based treatments, whether within juvenile justice agencies or facilities in the community. We must divert youth whenever public safety concerns allow, and redirect them to community-based treatments with proven effectiveness. We must use evidence-based treatments. Quite a lot is now known about the kinds of services and supports that work most effectively with the juvenile justice population. These interventions bring therapeutic services into the home in varying degrees of intensity and duration to work with the youth and family in natural settings. And we must keep youth out of adult jails. They suffer significantly higher negative outcomes than youth in juvenile facilities, from higher suicide rates to increased likelihood of being victims of assault or abuse. And when they are in adult jails, we must keep them sight and sound separated from adults so as to minimize the likelihood of their being abused or exploited. And states and local jurisdictions must be held accountable to assess and address the racial and ethnic disparities affecting youth of color that exist throughout the juvenile justice system. These basic protections must be a priority for this committee to ensure that youth in need of mental health treatment who come into contact with the juvenile justice system are, whenever possible, able to receive effective services in their homes or in the community. And these are the protections afforded by the JJDP Act. Thank you.
Thank you, Ms. Weissman. Mr. Amos?
Madam Chair, members of the committee, my name is Steve Ose. I'm an assistant director and an economist with the Washington State Institute for Public Policy. The Institute conducts nonpartisan research at the request of the legislature in Washington State. And I want to talk to you a little bit about today about what we have done in Washington State for our legislature, and some of the principles that we have found may be helpful to you as you consider reauthorization. Our legislature was interested actually in a broader question. It wanted to know how to reduce crime, one, and two, how to do it cost effectively, how to actually do the smart things so that you can reduce crime rates and save taxpayers money in the process. So we began to look at their request at a wide range of options in the prevention system, in juvenile justice, and in adult corrections. Conducting a thorough review of the research literature, we found 571 solid studies in all those areas, control group kinds of studies, what works, what doesn't, to reduce crime. We found some things that don't work and some things that do. And then we also did an economic analysis of those programs. What we produced then for our legislature is kind of a consumer reports, a list of what works, what doesn't, ranked by where we think the kind of rate of return we can give taxpayers with the different programs. That research has been used now by our legislature, I'm happy to report, in this 2007 session to substantially reform the way we spend our money in all three of those systems, in the prevention system, the juvenile justice system, and in the adult correction systems. What we did find when we did that work is that we think we can avoid building several new prisons, adult prisons down the road, particularly if we concentrate on some prevention programs and some juvenile justice programs. Those look particularly attractive to us economically. They can save taxpayers in our state a considerable amount of money. For example, let me just pick out one, and it's in the juvenile justice system, a program that we're implementing now in Washington State. It's called Functional Family Therapy. It was a program that was done outside of Washington State. We looked at it. We looked at all 7 studies that had been done of it. We thought it made sense. We imported it into Washington State, put it into our juvenile court system. The state funded that program. We've evaluated it. We found out that it is working, and pretty much as we thought it would once we had good quality control of that program. And we think it's saving taxpayers about $7 for every $1 it puts in. And additionally, because there are fewer crimes committed by those juveniles, we think it's about saving another $7 or $8 to the crime victims, people who aren't victimized. So its total return is about $15 of benefit per $1 of cost. So it looks awfully attractive to us. The lessons that I think I'd like to leave the committee with here, maybe if you want to learn anything about what we've tried to do in Washington State, it's that the first thing is that the research has progressed in the last 10 years. We know a lot more now about what works and what doesn't work. And that's useful to put that into action now. We've done it in Washington State. We would suggest it would be a good thing to put that information into play as you reauthorize. And the second thing that we've looked at is if you think about this as an investment, as you might do on Wall Street, what kind of portfolio of spending do you want to do? What we've tried to do in Washington is put an increasing percentage, the greatest percentage, 70 or 80% of what we spend our money on are on the things that are on this list, things that we already have evidence that work and don't work, and move money out of things that don't work and put it into things that work. And then reserve about another 20 or 25% for things that we don't know yet, whether they work or not. Research and development is what it's called in the business world. And to do those, put some of the money into that research and development part of the portfolio, and then make sure that we conduct those evaluations. So we're already on the road in Washington State. We think the legislature has taken a big step forward this session to try to implement some of these programs, some of these things that work. We've shifted money out of things that don't work. We were doing some things that didn't make any sense to us based on rigorous research, and we've moved those dollars into things where we think we can give taxpayers a better return on their dollar. Thank you, Madam Chair.
Thank you, Ms. Amos. Ms. Ambrose?
Thank you. Good morning. I am Anne Marie Ambrose, the Director of Child Welfare and Juvenile Justice Services for the Commonwealth of Pennsylvania. I'm happy to have this opportunity to be here today to represent Pennsylvania as well as juvenile justice administrators and advocates on the critical importance of the reauthorization of the Juvenile Justice and Delinquency Prevention Act. The JJDPA has been critical in supporting juvenile justice system improvement and for delinquency prevention. The establishment of Pennsylvania's State Advisory Group, the Juvenile Justice and Delinquency Prevention Committee, within the Pennsylvania Commission on Crime and Delinquency in 1978 has provided tremendous leadership and commitment to improving juvenile justice system and to provide a consistent focus on delinquency prevention. This important work has been accomplished over the past several years, primarily because of the strength of the JJDPC. We are appointed by the governor without regard for political affiliation, but based on experience, expertise, and dedication in the field of juvenile justice. Our committee is composed of judges, probation officers, researchers, youth and victim advocates, defenders, district attorneys, practitioners, community leaders, providers, and educators. We have the best and the brightest engaged in intensive discussions and planning to create a framework for juvenile justice and delinquency prevention goals for Pennsylvania youth and families. We believe in the fair, humane, and just treatment of all youth in the juvenile justice system. We believe that all youth have the promise and potential to become productive citizens through our juvenile justice mission of balanced and restorative justice, which includes protection of the community, accountability for offenders, and competencies to enable children to become responsible and productive members of the community. The JJDPC meets quarterly and submits a plan to the governor every 2 years. Subcommittees meet quarterly as well to drive the work and make recommendations in critical priority areas such as female services, evidence-based prevention, as well as disproportionate minority confinement. Through the years, our committee has used the goals of the JJDPA and critical federal funding as a springboard for juvenile justice reform that has become a national model. Devastating cuts in federal funding over the last few years have forced the committee to reevaluate our work and focus even more on prevention as well as sustainability of programs. Our key priority areas are evidence-based prevention, disproportionate minority contact, aftercare, and behavioral health. The JJDPC has used much of their federal funding over the years to invest in over 160 evidence-based prevention and intervention programs, such as multidimensional treatment foster care, functional family therapy, and multisystemic therapy. In the absence of any good research that establishes that public safety is enhanced by prosecuting juveniles in adult court or placing them in institutions, Pennsylvania has invested in supporting youth and families in their communities. In order to build our current prevention efforts and build more in-state capacity, planning is underway to develop a resource center for evidence-based prevention and intervention practices. As you have heard on this panel, these interventions are both cost-effective and have proven outcomes. Important resources like this require stable federal funding to succeed. In 2003, the JJDPC priorities became the foundation for our work with the MacArthur Foundation's Model for Change initiative. The partnership with MacArthur has been critical to advancing JJDPC's priorities in seeking to promote broad juvenile justice system reform in the areas of aftercare, mental health, and disproportionate minority contact. Pennsylvania believes in keeping children and families together whenever possible and using the least restrictive intervention necessary. We have implemented performance-based standards launched by the Council of Juvenile Correctional Administrators and supported by OJJDP to ensure quality of care in juvenile correctional facilities for youth who require secure confinement, but believe that most youth should be served in the community if possible. Pennsylvania SAG, the Juvenile Justice and Delinquency Prevention Committee, have helped to create a model juvenile justice system. In 2005, of 45,504 delinquent dispositions, only 3,487 youth were placed in out-of-home care. Much of our good work has been built around the core protections for children found in the JJDPA. Those protections should be maintained and strengthened through reauthorization. Our work has been made increasingly difficult because of significant cuts in funding. OJJDP should be charged with not only holding states accountable for adhering to the goals of JJDPA, but for providing technical assistance to states in order to achieve those goals. Incentive funding should also be made available for states that are able to demonstrate the ability to create innovative and effective local initiatives that provide treatment to youth involved in the juvenile justice system while keeping communities safe. OJJDP should be responsible for measuring outcomes in states that receive federal funding. Positive outcomes for youth, families, and communities must be achieved in order to maintain and increase federal funding. I hope that I've been able to communicate the critical importance of reauthorization of the JJDPA. It has helped create a synergy in Pennsylvania's juvenile justice system that recognizes the need to provide an opportunity for redemption for our troubled youth while valuing the importance of community protection and the community's critical role in achieving youth redemption. Our reform efforts would not have been possible without federal funding that was available over the last several years. In order to sustain our progress and continue to make critical investments in prevention, including evidence-based programs, we must receive additional federal funding. Thank you for the opportunity to address you on this very important issue. I encourage Congress not only to support, but also strengthen the JJDPA. Thanks.
Thank you, Ms. Ambrose. Let me say that we are working very hard to see if we can increase funding, because that's on the top of everybody's list. We're working under restraints because we do believe on doing pay-as-you-go, but we are going to try to do what we can. With that being said, listening to all of your testimony, and you're hands-on. I mean, you're the ones that are actually working with these young people. You can see the results. You see where the weaknesses are. As we go forward on trying to reevaluate the funding, certainly what can we do to improve the programs, and I think that's important where all of you come in. One of the things I would ask you, and you can expand on, because I know that 5 minutes is not enough time to go through everything you have to say. So one of the things I would say to you is, as we look at reauthorization, each and every one of you to give your opinion, what is the most important thing from what you see that we could do to improve the reauthorization? One of the things, before I came to Congress, I was a nurse. So to me, prevention, as far as I'm concerned, is the #1 issue. And hopefully we're going to deal with a lot of that as we reauthorize Leave No Child Behind, because again, when we see healthy children, children that are stable in school, that also will prevent, hopefully, down the road going into the juvenile justice system. So with that, I certainly would open it up to Judge Cooperstein, if you want to start on what you think is the one, and we'll take money off the table because we're already fighting for that.
All right. Taking money off the table. In terms of prevention, Congresswoman, even though I don't get to see people who haven't committed a crime or been arrested as a juvenile through the youth court, because I'm in a town and aware of what's going on in the town, basically from my successful drug treatment court teenagers, 2 of whom I've established a close relationship with. It's hard to believe, but I put them in jail, and now we have a relationship, which of course a judge is never supposed to have with a defendant, but in the drug treatment court it is permitted. And Matt tells me what he thinks, so I'd like to tell you what he says. He's 19 years old. He was a football star in Southampton High School, very bright boy, addicted to 3 different drugs, really destroying his life. And he told me that the DARE program is very good, but then after the 6th grade, there is nothing available. And those junior high school years are critical. We have puberty, which I believe is a very important thing to consider. And the brain is developing. New kinds of thoughts are coming into their heads. And the availability of the drugs, I hope we all understand, is there. So they're vulnerable. They're going through a phase of rebellion with their parents, and they need something to guide them. And Matt likes the youth court, but until recently, it was not very popular and supported. If we're talking about prevention, something involving that is very good to me. And that wouldn't even involve a judge. If you want real prevention, you want to have nobody get arrested, then we need to give our adolescents something else, because of the fact that the family alone cannot give them the support, because of the factors that face us in this country and in my town. A lot of it comes down to drugs. The availability of them, the susceptibility of an adolescent, and the fact that it's an experimental time and it's not a gentle time. So they're really out there, and we need to protect them, and we need them to believe us. Now, these teenagers can tell when you're not telling the truth, so they've held me to a very high standard, Congresswoman. It's been good for me. I learned to cut out a lot of the nonsense, and I talk very directly to them, and they respond. You know, they really do respond if they see you take a real interest. Even the hardened ones, even the ones doing oxy every day, ecstasy at night, all the things that Matt was doing, pot, coke, everything. He finally was able to believe somebody was really not just pushing them over. They're going through a phase. Let's just wait it out and hope for the best. So those are my thoughts.
Thank you. My fault explaining, being that I just wanted to have try to get an answer from each one of you. If you could go a little bit faster and just sum up the one issue that you think is important that we do. Ms. Clark?
Thank you. I think certainly prevention is important, but there's another thing that I'd like the committee to consider in terms of those children that are already in the system and are about to age out, either the juvenile delinquent children that we have placed in, they're in placement, they're getting ready to turn 18 or in some cases 21, and we have to close the books on them, and we have not provided them with the skills to make it on their own. The children that are in the child welfare system who are about to age out of the system and they're homeless, they have not achieved their education, and we have not provided them with the tools that they need. I think this is something that we really need to focus on with these kids. We've seen an increase of even older children entering the child welfare system, becoming dependent at 14, 15, and 16 years of age, and we have a little bit of time to work with them, and we need funding for programs that can help these children.
Thank you, Ms.
Thank
Clark.
I would say that early identification of youth maltreatment is really the key to diverting youth out of the system. We often assume that youth become dependent and then they are later found delinquent. What the NCJJ study found in Arizona is that it often is the delinquency that sheds light on the family and exposes the years of abuse and trauma that the child has suffered. So if we can identify early kids that are being maltreated and provide intensive family services when possible to preserve and heal the family, then those youth will not continue down the road towards delinquency.
Thank you, Ms. Garcia. Ms. Weissman?
Yeah, I actually agree. We should not be surprised that the evidence-based practices that have proven most effective are those that work with the family. As has been mentioned, multisystemic therapy, functional family therapy, multidimensional therapeutic foster care. All of those are strategies that work in the natural setting and with the family unit as such. And I think that the system of care values and concept of all agencies working together promotes that kind of, those kinds of effective treatments. I think the most important issue is, again, the significant trauma and abuse that so many of the children have experienced. And again, as I said, it is multi-generational, and unless we work with the family system per se, we are not going to be effective in working with youth individually. And so I would encourage us to take more of a public health view on the ills of our youth, and especially those that do wind up coming into contact with the juvenile justice system.
Thank you. Ms. Thomas?
Yes, I would suggest that if the authorization focus on evidence-based treatment practices. Wheels cost a lot of money to invent, and we don't need to reinvent some of these. It takes millennia to invent wheels. And there's already a number of models out there that have been shown to work, including nurse-family partnership, Madam Chair, that employs nurses as a form of prevention. And then the other programs have been mentioned. So if I were to offer one bit of advice, it would be, again, to put a substantial portion of what you do in the reauthorization into programs that have already been shown to work, that we don't need to reinvent the wheel. It costs a lot of money to do that. Let's just go out there and do the things that can actually, that we are pretty confident at this stage, that reduce crime.
Thank you. Ms. Ambrose?
Yes. I would recommend strengthening the Office of Juvenile Justice and Delinquency Prevention so that they're actually holding states accountable for doing good things for youth in the juvenile justice system, and then providing incentive funding for use of evidence-based practice and prevention services for youth that we know work.
I want to thank you all. Mr. Davis?
Thank you, Madam Chairwoman, and thank you, panelists, for being here today. You've offered some great testimony. Judge Cooperstein, thank you for your support of the Vols. I appreciate that. We've talked a lot about outcomes today. I wish we had a different outcome this past Saturday. It wasn't as good as I'd like for it to be. How are youth chosen for your youth court?
Beginning this year, they are referred by a probation officer, a juvenile probation officer, from her docket.
How many have actually participated in youth court to date?
Well, if we begin from the beginning in the early 90s, I would say well over 200, but but the statistics and documentation is scant. But in the last year, we had 36 participate. By that I mean also staff the court, be the judge, the jury, the prosecutor, and the defendant. We've had 6 trials to date this year, and they are lengthy, and 2 of them involved substantial drug cases.
Tell me about one of your major success stories through the drug court.
I've spoken about Matt, but I'll tell you about someone else, another teenager who was a cocaine addict who came into the treatment court pregnant. Very soon after she entered, we found out she was pregnant, and she got clean. And that was highly significant because not only did she get clean, but her baby was born drug-free.
That's a great
That's
success.
a double success.
That is a great success story. Thank you. Just real quickly, Mr. Ose, if you would, could you tell us, in your testimony you discussed research you conduct on evidence-based approaches. Can you tell us how you define those evidence-based approaches? The microphone, please.
I didn't need, before he started this job, I didn't need reading glasses. I do now. What we found them was by searching all of the well-researched things that have ever been tried anywhere in the country. And so we really combed all the research studies, throwing out the ones that didn't have good comparison groups, and just keeping the ones that were very well-controlled trials at these interventions. And so when we come to conclusions about what works and what doesn't work, it's based on those rigorous studies that have been tried somewhere in the country. Some of them have been in Washington State. Most of them, of course, have been elsewhere.
Did those approaches actually net an economic return?
Pardon me?
Did you see some economic benefit from using those approaches?
Yeah, so after we reviewed all the literature to what reduces crime or child abuse or any of the other outcomes of interest to our legislature, we then put on our economic green eye shades, and we said, well, how much money does it cost to do those programs on the one hand, but then to the degree that they achieve an outcome that our legislature was interested in, like less crime or less child abuse, what's that worth to us in Washington State, both as taxpayers, because if we reduce crime, we don't have to spend as much on police and as prisons, and also to the victims who aren't victimized as well. So we added up the benefits, calculated what we thought are the reasonable assumptions about the benefits of these programs and the costs based upon that rigorous research. So that's sort of the green eye shade thing that we did to try to come up with our list.
Thank you. And then I have one last question, and I'll have Ms. Ambrose. First, let me say congratulations on being selected for the first state to participate in the MacArthur Foundation's Model for Change. Can you tell me how your state was selected?
Yes, there was intensive research done by the MacArthur Foundation. I think there were lots of reasons why Pennsylvania was selected, and the main reason was probably the strength of our Juvenile Advisory Board. We had lots of leadership in place that were already engaged in many reform efforts that MacArthur research showed were reasons to invest in juvenile justice. And so we feel very fortunate to be part of that network. There's a national resource bank that's available to states who are participating in the effort. And so we have been real recipients of additional not only research but expertise nationally in order to advance our juvenile justice reform efforts.
Thank you, and I yield back.
Thank you, Mr. Davis. Mr. Scott?
Thank you, Madam Chairman. I want to thank all of our witnesses. This has been very helpful testimony. Mr. Oates, you indicated that you could reduce crime and save money by focusing on well-researched programs before crimes occur rather than wait and try to lock people up after they occur. Is that right?
That's correct.
And I wasn't sure whether you counted in cost savings. Did you count just the criminal justice costs, or did you add in the cost to victims and other costs to society?
Yes, Congressman, we did both. We certainly were interested in any savings that would accrue to taxpayers, but we also added up the if there's less child abuse, if there's less crime, there's going to be savings to people who aren't victimized, to kids who aren't victimized, to other people who aren't victimized by those crimes. So we used actually some numbers that were computed for by the federal government to estimate those victimization cost savings, avoided costs, so that our estimates do include both of those.
Did you include savings that would be generated by reduced welfare, because some of these programs, by empowering children, getting them on the right track and more likely to be employed and need social services, did you count other savings outside of the criminal justice system?
Yes, sir, we do. When we think there's a reason to believe that some of those savings are causally related to the outcome achieved.
Okay, thank you. Ms. Weissman, what can we do in the foster care system to help reduce crime?
Again, I think that that multidimensional therapeutic foster care has been shown to be effective. It's one of the most intensive home or foster home-based interventions that can be provided. But there's just not enough of it. In the district, we have very few slots, as they say, and there's just an under...
well, those that go from foster home to foster home are at high risk of getting in trouble, and we end up spending a lot of money on them. Would it make more sense to spend the money up front in the focused foster care programs that you're talking about, or would it make more sense to spend less and wait for them to mess up and spend millions of dollars on prison and other costs?
Well, clearly the answer is yes, it would make more sense to spend more money earlier on and not to have these youth progress inevitably into more expensive institution-based, whether they be juvenile justice systems or prison systems, adult correctional systems. Whenever possible, some of the evidence-based practices should be attempted in the home. I think youth who bounce from foster care, from one foster care to another foster care family, are doubly, triply, and exponentially further traumatized by those experiences. We clearly don't want those things to happen, and clearly there needs to be more training, more support services to those families that would serve as foster care families. They do, frankly, much better with younger youth, but when the youth reach their teenage years, then they are becoming involved in the juvenile justice system. Inevitably, the overwhelming number of kids in the juvenile justice system have started out in the child welfare system, and so a lot of further attention and resources need to be spent in the child welfare system, working with families, reunification, and options for them in their natural homes and settings.
Does that include possibly helping children 18 to 24 who, quote, age out of foster care?
Yes, as a matter of fact. I'm agreeing with Judge Clark, who noted her concern and the field's concern about the lack of independent living programs for these youth. In fact, my husband and I took in a youth at that juncture in our own lives, a youth who had aged out of the foster care system and had nowhere to go. We took her in at that point and helped her to become independent and self-sufficient, but there need to be more families like ours, and there need to be more programs that truly work with the youth on their life skills and abilities to take care of themselves in the community.
Thank you. And I wanted to ask one other question for the record, because I know my time is up, and that is if the panelists could just tell us what's wrong with locking up juveniles with adults and what's wrong with locking up status offenders. And those are part of the core requirements of the JJDP-A, and we just want that for the record. What's wrong with locking up juveniles with adults and locking up status offenders? And I'll yield back.
Are we waiting for somebody to answer? I'm happy to answer.
Well, my time is up, and Ms. Clark, I think, wanted to ask a question.
The bills that you heard, we have to go down for a vote.
Oh.
So, Ms. Clark? if you would go forward. But with Mr. Scott, I know that he would like an answer, and possibly could they write it up to us and get it to the committee? That'd be great. Ms. Clark?
Thank you very much, Madam Chair, and I want to congratulate you on this very excellent panel and thank our panelists for their commitment to the area of this area of expertise. I'm from New York City, and there's a debate that has begun to simmer regarding the police presence in our public high schools, the impact on the development of at-risk youth in our schools, which have been labeled or stigmatized as most dangerous as part of the No Child Left Behind authorizations. Behaviors that a couple of decades ago may have sent students to the principal's office for detention now can send students to the local precinct for detention. Could you give us a sense of, in our search for safety and security in our school environments, are there some unintended consequences that we need to take heed with, or are we creating a culture of self-fulfilling prophecy given the social and mental indicators that many of you have talked about with respect to juvenile delinquency? And I want to direct this question particularly to Dr. Weissman and to Ms. Garcia, as you spoke about early identification. Our public schools tend to be that place. And if anyone else wants to, given what the time constraints.
Yes, absolutely. Schools are the place. Most grade school teachers will tell you that they can identify the young people who are going to be in trouble. So they are the place. And I'll tell a story that one of our judges tells about a young person that came to their detention center. He was acting out in the classroom when they were taking the high-stakes testing that Arizona does, the Ames test. He refused to take the test, was flipping ahead on the test, an ADHD child. When the teacher redirected him, he got mouthy. She called the principal. The principal came in. The resource officer came in. The kid got a little aggressively acting out. Police were called, ended up in handcuffs, ended up at the juvenile detention center. The kicker to the story is the child was 8. So I think that, and she tells that story to show how far it's sometimes gone, that schools feel that they have to be so focused on high-stake testing and getting the No Child Left Behind met that they forget about the social needs of the child. And it is, schools have a lot on their plate, but we definitely need to support them and fund them and provide services at the school level in order to identify and provide services to young people to keep them out of the system.
Yeah, when I was working in Maryland, nearly 1/3 of all the arrests in Baltimore City came from the schools. These were school-based arrests for behavior that was engaged in the school. Disruptive behavior, to be sure, but not the sort of behavior that required a youth being locked up for it. It is unwise and unwelcome to have youth who engage in disruptive behavior treated by the juvenile justice system. Indeed, the juvenile justice system has become the repository for kids with behavioral and emotional health problems, and that's really wrong. There are negative outcomes because there are kids who do commit offenses and who do require, for public safety concerns, being locked up, and putting all youth together under the same umbrella and in the same facility means unwanted outcomes for those who should not be there.
Congresswoman, could I just briefly? Congresswoman, I agree there are unintended consequences. In our little town, though, there are police officers who are very good with the kids, and it is overkill to bring in a force and then just arrest. But if we could build on the DARE program, which in our town is run by police officers who have the skills, and I don't mean just the police power to put on the cuffs, I mean who care and can relate. If we build on that so that those are the officers called if there's a disruption in the school, because an officer who is well trained can diffuse a situation. that officer doesn't have to just say, you're going in, you're getting locked up. So I just ask you to think about that too.
When I first took the bench in 1999, we had an influx of juvenile delinquency petitions being initiated by the school system, assaults on teachers, which are felonies, and some of them were two kids getting in a fight, the teacher goes to break it up and the teacher gets knocked down, no injuries. And it got to be problematic, and one of the things that our judges did was meet with the school officials to say that we're not going to allow all of these cases to come into court. In other words, sometimes I guess the judges have to take control of their own court system and provide some reasonable alternatives for what can be done for some of these children. Disruptive behavior is very different than criminal behavior.
Right.
And status offenses are offenses that should not warrant incarceration or removal from home, but providing services to work or to try to identify why children are engaging in these behaviors. In other words, making some assessment early on and an appropriate assessment. But at some time, the court has to, I think, take control of the situation and to say, and be in control of its own court, because they can file a petition, but the court has to intervene and take some action as well.
Thank you, Ms. Clark. As you heard the bells, we're voting. So I'm going to submit my closing statements for the record. What I want to say to each and every one of you, again, I thank you for your service on what you're doing back in the community, but I also thank you for coming here in front of us and giving this information. I've been here in Congress long enough, and we're going to work really hard on the reauthorization, but I also know we won't have every solution, but it will be a start, and with your testimony, it gives us a lot of food for thought on what needs to be done. The ray of hope that I also see is we are reauthorizing Leave No Child Behind. There are going to be a lot of different programs in that particular reauthorization that hopefully will work with our young people from pre-K and through junior high. The DARE program and many other programs, why in God's name they forget middle schools, I have no idea. I mean, that is when almost all students, especially our young women today too, need that extra help. So hopefully we can do something about that. And the most encouraging thing is, through this committee, we were able to pass a mental health parity program, which I think has long been in need for not just for children, but for adults also. The world has become more aggressive. We see our young children, I see my grandchildren, certainly more aggressive than some of us were brought up. And those are situations that the schools are having a hard time dealing with. We have teachers that are supposed to be teaching, not being social workers, not being police officers in the room. So as I said, we're not going to be able to have all the solutions, but with your testimony and your information, hopefully we're going to make it a better bill and have hopefully the end goal, protect all children of this nation and make them good citizens. And that certainly is the goal of this whole committee. With that, I have to do this thing. Nobody's here anyhow. As previous ordered, members will have 14 days to submit additional materials for the hearing record. Any member who wishes to submit follow-up questions in writing to the witnesses should coordinate with the majority staff within the requested time. Without objection, this hearing is adjourned. Thank you.